Please be seated. Good morning. Before we begin, for those of you that don't know, I think I'll introduce the members of the court. On my far right is Justice Dirk Sandifer, and then Justice Beth Baker, Justice Ingrid Gustafson. On the far left is, my left, is Justice Jim Rice, Justice Jim Shea, and Justice Lori McKinnon. And I'm Chief Justice Mike McGrath. And this is the time set for the oral argument in cause number EA 230575, held et al. Versus State of Montana. Counsel ready to proceed? Mr. Schoengert.
Mr. Chief Justice, and may it please the court, Dale Schoengert for the state agencies and the governor.
Please speak into the mic. It's hard to, for those streaming, it's hard to hear if we don't.
Thank you. I'm here with Mark Sturmitz, who represents the state. We'll be splitting argument. I'd like to reserve 5 of my 20 minutes for rebuttal, if I may. Global climate change and the sensitive policy issues surrounding energy, stable and affordable energy development are undoubtedly important. This case involves the limits of judicial power to resolve those issues. To safeguard judicial power and respect the separation of powers, this court has said that plaintiffs must show that their injuries were caused by the statute that they're challenging and will be redressed by striking it. The plaintiffs can't meet that burden here, and the district court erred in concluding that they could for at least 3 reasons. First, agencies are explicitly prohibited from denying, revoking, or modifying permits based on MEPA analysis. There's no evidence in the record that striking 75.1.201.2a would or even could result in a single permit denial or reduction in greenhouse gas emissions. Second, even if agencies could deny permits based on MEPA analysis, global climate change is a complex issue that can't be resolved by judicial decision. That's the conclusion of every appellate court to address this issue to date and address very similar claims to the plaintiffs. Even eliminating all greenhouse gas emissions won't alleviate climate-based injuries. Third, even if it could, the district court's analysis inflated the greenhouse gases Montana can lawfully evaluate or regulate. By my count, at least 80% of the greenhouse gas emissions the district court attributed to the state can't be analyzed or regulated by state agency. And it ignored, just as importantly, the exceptions in 75.1.201.2b that allow analysis of greenhouse gases when done with a federal partner. That includes the most significant greenhouse gas emissions identified by the state, such as coal combustion in other states. I'd like to start with the limits of MEPA. The purpose of MEPA is informational. It's an assess and disclose statute. The plaintiffs here aren't challenging information. They're challenging what the state does, namely permitting greenhouse gas emitting projects.
And counsel, I think that they are challenging the information that is before the agencies when they make their decision.
But what the plaintiffs alleged and what the district court concluded was that the agencies could deny permits based on those allegations, or based on that information. They can't, and that's explicit under 75.1.201.4a. The agencies can't deny permits based on MEPA analysis. And that really gets to the crux of the plaintiff's claims. And in the district court's analysis of redressability and standing, or causation and redressability, was at pages 87 and 90 of the opinion. And the court didn't connect plaintiff's injuries to MEPA. In Larson, this court said that the alleged wrong, plaintiffs have to show the alleged wrong was in fact caused by the statute or likely to be caused by the statute, and then that specific harm was alleviated by striking it. MEPA analysis can't result in permit denial. What the district court did, and this is at page 89 to 90 of that opinion, was assumed that the permitting statutes themselves could be denied based on greenhouse gas emissions, despite direct record evidence to the contrary at trial transcript 1389 to 90 from the DEQ's division administrator testifying that that's simply not the case. In the alternative, the district court said that if they don't allow denial of permits based on some unspecified level of greenhouse gas emissions, then the statutes themselves are unconstitutional. That was the basis for the district court's conclusion that the plaintiffs had shown causation and redressability. That was an advisory opinion at best. Not a single permit or permitting statute was challenged in this case, not under the MMRA, the Open Cut Mining Act.
But counsel, how could they be? MEPA prevents, the limitation prevents consideration of greenhouse gases. And that would apply as well to those substantive statutes.
Plaintiffs, the way this court has always dealt with MEPA's challenges is in the context of a permit challenge. Plaintiffs who live and recreate in the area come to court and say, the agency should have conducted analysis but didn't, and they challenge either the analysis or the statute governing that analysis, as in MEIC 1 in the 1999 case. And then the relief is that if they're right, the court vacates that permit. And the court goes through that in Park County and cites a bunch of cases with that exact analysis. That's what makes this case really unusual. It's the nature of the harm and the relief required to alleviate that harm that puts this outside the context of a normal case. And it also is what introduces state agencies and the courts entangles them into very difficult policy issues. And the district court's, I think, decision at page 90 is a great example of that. What I think makes the district court's decision worse, beyond just assuming that state agencies could deny permits, is that the court assumed that those state agencies would deny permits based on some unspecified level of greenhouse gas emissions that violates the Constitution.
Well, if we get beyond the issue of, or if we get away from the issue of denial of permits, I mean, I think in your brief points out the issue in this case is a really narrow one. The issue is whether the legislature complied with the Constitution by foreclosing any review of this issue of greenhouse gases. And the review, I mean, the purpose of MEPA is to inform the agencies and the public of the, considerations of impact on the environment. And so if the only issue is whether the information, as Justice McKinnon said, the information is being completely foreclosed, does it matter that the denial is, I mean, I guess the scope of review or scope of the district court's order, the scope of relief becomes really the important issue.
In part, and first of all, the statute doesn't foreclose all review. It allows review, and I think the exceptions in 2B are important when analysis is conducted with a federal partner, or if the federal government amends the Clean Air Act to include carbon dioxide as a pollutant. But to the broader point, the claims that the plaintiffs are making in this case aren't based on information. They're based on, they're on what the state does, the permitting decisions. That's the basis of their harm. That's what they're claiming would be redressed, and that's what the district court said would be redressed by denying permits. Information can certainly be important in permits, but the way that's always been challenged is in the permit itself, to show that the substantive permit requires that analysis or should require that analysis, that it wasn't done, and that and the court could vacate the permit on that basis. But what makes this case different is, like I said, the nature of the claimed harm and the remedies required to redress that harm, because it entangles courts in determining how much greenhouse gas emissions is too much.
But counsel, it doesn't. It doesn't. All it is doing, it's a limitation that that is being challenged here that respects information before the agency, the permitting agency. It doesn't have anything to do with a specific permit. It has to do with whether this aspect of the environment should be considered when evaluating a permit. We're not, nobody, and in fact, the district court refused to implement some sort of plan that set forth the amount or whatever. So this is a very narrow question.
But it should be in the context of a permit. And I'm not sure that that's accurate what the scope of the district court's decision. I think it's unclear. The district court's decision assumes to suggest that agencies have to have discretion to review greenhouse gas emissions, have to have discretion to deny permits based on that basis if they violate constitutional rights. That puts agencies in an untenable position because there's no standard to judge that by.
Well, it's a process that evolves. But right now, nothing can evolve.
But it could evolve if plaintiffs could make. There's no reason plaintiffs couldn't make claims to a permit itself. Now, they wouldn't be based on global climate change. They'd be based on specific harms, just like this court has always analyzed. But just because it's a facial challenge, the plaintiffs still have to show causation and redressability.
But they can't make that challenge because of the limitation.
I don't know why they couldn't make that challenge if they file a lawsuit challenging this provision and saying in the context of whatever permit under the Montana Clean Air Act or whatever they want, that greenhouse gas emissions should be included. The statute prohibits it, and then they can challenge it that way. That's the way the court has dealt with these MEPA challenges. And I'd like to go to the second point, that the complexity of the issue and the unanimity of courts in dealing with this issue. And I want to point out a few things. One, these were cases where same plaintiffs, same organization that's bringing these claims, very similar to the claims in this case, except that those cases were actually challenging the permitting activities, funding, and promotion of fossil fuel permits, not just the procedural statute. But even there, and second, it was from the Ninth Circuit, the Alaska Supreme Court, the Washington Court of Appeals, the Virginia Court of Appeals. These were courts that were not unfriendly to plaintiffs' claims, just the opposite. They recognized the serious issue of climate change, but they also recognized the limited authority for a court to solve that problem.
Right, but in all of those cases, there were challenges to the actual implementation of plans. It wasn't the same claim that's being made here.
But I think that's what makes their cases more justiciable, not less. I mean, the problem is that the plaintiffs aren't challenging the actual plans. To redress their climate-based injuries, it would require a stable climate. That would require, actions by the state. That's not, challenging MEPA doesn't get them there because it doesn't allow the agencies to deny, modify, or...
So you're saying they would never have standing because if they did challenge a permit, they couldn't show that permit alone could impact global climate change.
I don't think they could challenge it based on global climate change, and that's where all these courts land. That issue is a complex global issue that can't be affected by one state's emissions. The Ninth Circuit said if the federal government stopped overnight all of its emissions and permitted activities that create greenhouse gases, it wouldn't alleviate plaintiffs' claims in that case. So that's the difficult. But they can make a claim that they live and recreate in the area. If they believe carbon dioxide is a pollutant that will impact their recreational activities, or however those claims are structured, they can make the claim that they are impacted, and then that remedy would be vacating the permit, because if they're right that the analysis should have been done. And that's what Park County was. That's what MEIC one was. And like I said, in Park County, the court cited in its standing analysis several cases that follow that path. So there is a remedy. It's not immunizing. It's just, but it is also saying that this is a complex issue that can't be solved by, as the Ninth Circuit said, judges. It is, for better or worse, a political question. And these are cases that also, I want to point out, assumed a broad constitutional right similar to the right to the clean and healthful environment. Each of those cases did. Nonetheless, it held that this is a complex issue and one that there's a lot of competing interests. And I think there's no doubt that the state is funding renewable energy. We're transitioning to renewable energy. Northwestern Energy's amicus brief details some of those efforts. The legislature's amicus brief does as well. But there are a lot of competing interests. I mean, the technology is not there to get transmission lines, for example. That especially impacts lower income Montanas because it affects affordability. These are competing interests that legislatures have to wrestle with as we do transition to renewable energy.
So, counsel, how does your argument, your position, allow for a challenge to a fossil fuel plant in Montana by a neighboring community, members of the neighboring community?
If the neighboring community says, look, this plant emits carbon dioxide, for example, we live near the plant, we are impacted by that. That's how they can challenge it. That's how, like I said earlier, that's how MEPA challenges are always been done.
They would have to challenge the limitation in MEPA.
Yes, in the context of a substantive permit, yes. And this court entertains those challenges to MEPA analysis in the context of a permit. I'd like to touch briefly on the district court's, the district court included emissions such as emissions that were, or resources that are transported through Montana, not combusted here, included resources extracted in Montana, like coal, combusted elsewhere. Agencies don't have, even if they had authority to deny permits, agencies don't have authority to regulate activity outside the state. They're limited by this court's decision in Bitterrooters, and they're limited by the Dormant Commerce Clause that strictly prohibits that. Federal government is not. That's where the exception in 201(b)(2)(b) comes in. The federal government can go beyond state boundaries and evaluate those impacts. And that's why I think the exceptions in 2B are important and potentially encapsulate the majority of the greenhouse gases identified by the state. Unless there are more questions, I'd like to reserve the remainder of my time for rebuttal. Thank you.
Mr. Sturmans.
Morning, Mr. Chief Justice, Your Honors. May it please the court, Mark Sturmans representing the state of Montana. In the Park County case that's just been mentioned, this court said, quote, "We are not asked here to engage in a difficult exercise of determining what attributes constitute a, quote, clean or, quote, healthful environment or an unreasonable amount of degradation, or what the judiciary's role should be in answering these questions." We believe that that day has come with this particular case. But the MEPA provision that's in question here doesn't involve a mine exploration permit, as in Park County, or water use permit like Water for Flathead's Future, or non-degradation review like MEIC1. It involves no permit action or inaction by DEQ at all. It doesn't involve even an existing or potential environmental problem specific to Montana. One of the things that runs throughout the district court's findings is that at trial we did not contest, allegedly, many things. But I'd like to, if I could, point out right up front that the plaintiffs' experts themselves testified to key facts that undermine the very fundamental premise of the district court, and that is that the court has the power and the practical ability to redress plaintiffs' injuries. For example, Dr. Running, Steve Running, a Nobel Prize-winning scientist from the University of Montana, highly respected international scientist, was asked this question: if the judge ordered that we stop using fossil fuels in Montana, what would that get us to the point where these plaintiffs are no longer being harmed, in your opinion? He said, we can't tell in advance, because what has been shown in history over and over again is when a significant social movement is needed. It often started by 1, 2, or 3 people, and so if our state decided to do this, do what you're hypothesizing, we can't tell how many other states would decide that's the right thing to do, and we're going to do it too. Then the question was, is that a scientific opinion or a personal opinion? That probably gets to be half of each. A more pointed question was asked of the plaintiff's experts on glaciers. Again, a highly respected USGS scientist who studied glaciers for his entire career. And he was asked whether if we sited a fossil fuel plant right upwind of Glacier Park in close proximity, there were any studies that could tell us whether there was any impact in Montana or specifically on the glaciers. And he said, no, he was unaware of any such information. Other experts, including the expert that tallied Montana's alleged contribution to global CO2 loading, made the same statements because they were honestly recognizing the fact that this is a global problem. But the district court waded into this strongly, despite these acknowledgments by plaintiff's witnesses that the ability of the court to address the problem was extremely limited, if not non-existent. The judgment of the court itself, the judgment says, this judgment will influence the state's conduct by invalidating statutes prohibiting analysis and remedies based on greenhouse gas emissions and climate impacts, alleviating youth plaintiffs' injuries and preventing further injury. So the key directive from that judgment was the idea that it would influence the state's conduct. I'm unaware of any case where that standard is an appropriate one for a district court to rest their entire decision on, especially in a case of this magnitude. I think it's a tacit recognition that the court was getting into the political arena.
Counsel, what the court was doing was saying this information needs to go before the permitting agency, or this information, the limitation shouldn't be there, the complete absence. There wasn't a direction as to how that information, if it was in front of the agency, was to be utilized. It's just that this information should be there, which I think was also the case before the 2011 amendment or limitation was put on in the statute. They were considering greenhouse gases.
The problem with that, Justice McKinnon, is that the judgment of the district court gives no direction on the threshold level that's to be considered. Right now, we're left with the conclusion, as the findings state, that every ton matters, quote unquote, and that's the plaintiff's case. Every ton matters. So at this point, the concept is that it doesn't matter one iota about the actual potential for a project to have an effect, or not even an effect. We know it can't on a global level, but that includes greenhouse gas emissions, for example.
So where in the district court order does it require the department to consider greenhouse gases?
Well,
It doesn't do that.
I agree with you, Mr. Chief Justice, but the plaintiffs certainly think it does. I mean, the record shows that just...
Where the district court did not require the department to
We
consider.
were threatened with motions for contempt for not evaluating greenhouse gas emissions as required by this
Well, but
judgment.
that's not before us.
But it points to the problem, which is that there's a dearth of information about exactly what this means, especially when you consider, you know, the Bitterrooters and the fact that for a MEPA, we don't do MEPA analyses just as a science fair project, so to speak. I mean, they're done to inform, as Justice McKinnon said, but they're not done to inform on areas in which the state has no authority, or DEQ has no authority to control. And this is an area where, as all the other courts that have looked at it say, it breaks down at the point when you take the information from whatever project it is and tie it to the action that's on the table and whether the state can have any impact whatsoever on the, alleged problems that that action causes.
So counsel, but that's inconsistent with what Mr. Schoeninger just said, which is that if you've got a fossil fuel facility that's being permitted in Montana, that local community member can challenge that appropriately. And it just is circular. Now you're saying that there would be no redressability because of global warming internationally. And so we have the constitutional provision that protects just that situation.
I don't want to disagree with Mr. Schoeninger, but I think the point he was making is that, you can challenge people have the right to challenge permit decisions. And if they did that and that analysis, whatever it was, say an air quality permit, had an element of fossil fuels or greenhouse gases associated with it, and if they believe that the agency didn't do an adequate evaluation of it, they could sue for that. Now, somebody else asked the question, well, could they ever succeed? Right now, there's no statute in Montana that gives DEQ the authority to analyze greenhouse, never mind the prohibition. I mean, removing a prohibition doesn't grant authority. They're two different things, as the district court
Well,
acknowledged.
sure, it's the first step. It's potentially the first step in a process. They can't even get there right now with that limitation.
Well, the first step in the process would be the submission of a permit application.
Well, getting back to Justice McKinnon's earlier question about what happened before 2011, because I guess it's your position that the Montana Clean Air Act has never allowed consideration of greenhouse gases. So under what authority did the DEQ consider it prior to 2011, which admittedly that agency did?
Well, I want to be clear, and if I wasn't, I apologize. But I mean, I think, there's a difference between being able, doing something and being required to do something. And my point was, I don't think it's required. In fact, the MEPA limitation itself recognizes this to an extent when it says that this will change if this EPA declares CO2 to be a criteria pollutant, which is at the root of a lot of this. It's not a pollutant that's regulated by EPA as such. And, Montana can make rules for various things, but they're subject to EPA oversight on everything. The state never did contest, and I hope this is clear, that there are anthropogenic human factors that contribute to this problem. And we were concerned at that point, sort of got lost at trial. But that doesn't mean that we feel that this global problem can be influenced in any way by a state district court judge in Montana. The issues of justiciability and redressability that Mr. Schoeninger referred to are the same threshold, constitutionally based issues as in any case filed in the state of Montana. From that standpoint, this case is pretty straightforward. If those are applied in the same way that they are normally, this case should have been decided on summary judgment.
Counsel, you've got Schoof versus Nesbitt, which recognizes standing based on a violation of a fundamental constitutional right, that there's a concrete injury. And I noticed Schoof was not cited in any of the state's briefs.
That's right. And I will say in all candor, it's not because we were avoiding it. I'm not aware.
Okay.
But that being said, There has to be, that case and any other like it aside, a direct connection, causal connection between the injuries the plaintiffs are alleging and the relief that they're requesting. And that's what's lacking here, because the court does not have, never mind the legal power, the practical power to make that connection. As Dr. Running said, or other plaintiffs' experts, we can eliminate every ounce of fossil fuel use in the state of Montana. No cars, no power plants, no nothing, and it will not impact the injuries that the plaintiffs are alleging. And that's an immutable fact because of the nature of the problem. And that's what has caused the other courts to dismiss the claims that are similar to this one that have been brought. I'd like to reserve 5 minutes as well, if I might, if there are no more questions. Thank you very much.
Mr. Sullivan.
Good morning, Your Honors. On behalf of the youth plaintiffs and my co-counsel, may it please the court. This case is about Montana's climate, Montana's constitution, and Montana's children. These courageous young Montanans who are present in the courtroom today testified about the impacts of extreme summer heat while working on the family ranch, about their inability to breathe clean air as a result of the new smoke season, about maintaining ancient tribal traditions tied to the seasons in the absence of winter snow, and about impacts to their cherished landscapes all across our state, from the grandeur of our mountains to the vastness of our rolling plains.
I'm sorry, could you pull the mic in a little closer, just for purposes of those who are streaming the argument? Thank you.
Now before you is an unparalleled trial record, with findings of fact based on testimony of the youth plaintiffs and Montana's renowned climate scientists and medical professionals, which established the reason there is a constitutional injury is because the legislature told the state agencies that they could not look at the impacts on Montana's climate on the fossil fuel activities they permit, and so the agencies haven't, which is why the record shows that they have never denied a fossil fuel permit. This record also shows we are in a climate emergency, and additional greenhouse gas emissions will cause additional heating and additional injuries to plaintiffs. The state doesn't challenge this evidence, on the basis of which the trial court determined that the two challenged statutes are unconstitutional because they have already caused the degradation of Montana's environmental life support system, and they threaten further violation of the youth's anticipatory and preventative rights to a clean and healthful environment. The MEPA limitation forbids Montana's agencies from evaluating greenhouse gas emissions and corresponding impacts to the climate in the state or beyond the state's borders when evaluating and issuing permits for fossil fuel-related activities. And to be clear, that's subsection A, and it was only subsection A that was declared unconstitutional, as a review of the order will reveal. Subsection B was left intact, and of course, as we've pointed out before, there's a severability clause. So I think that easily dispenses with the arguments that you just heard from counsel. The judicial prohibition, on the other hand, prevents Montana's courts from vacating or denying fossil fuel-related authorizations based on the agency's failure to conduct the forbidden evaluations. This legislatively imposed double-headed hydra closes the eyes of Montana's environmental agencies to the most serious environmental crisis Montana has ever experienced, the climate crisis. And it closes Montana's courthouse doors to those seeking redress from the harms hidden from the agency's eyes. And yet the state asks you to adopt two flawed arguments. First, The state wants the court to make the test for standing more rigorous than proving a constitutional violation. They don't cite a single Montana case for that proposition, and it should be rejected outright. Second, the state asks you to rule that neither the Constitution nor MEPA provide any protection for these young Montanans because MEPA is just an empty process requiring them to check a box. All they need to do is look, disclose some impacts, and continue to cause constitutional injuries. But that's not what MEPA's purpose is or what the Constitution requires. As you've just heard, the state relies on two lines of authority in attacking the district court's decision, and I'll address them in turn. First, relying on Bellin and Juliana cases under federal law, the state frames its standing argument untethered from Montana's constitutional rights in arguing that causation and redressability are impossible to establish in this case. And second, relying on Bitterrooters, the state argues that standing fails because the challenged MEPA statutes can have no effect on the agency's permitting activities. Turning to Bellin and Juliana, those cases underscore the weakness of the defendant's argument because they cannot win on Montana law. Defendants do not reference a single Montana case where this court found standing was lacking based on causation or redressability. Instead, they rely on Ninth Circuit decisions that never went to trial, don't bind the court, and aren't persuasive. And here, unlike Bellin, where the court determined that the vague and conclusory standing affidavits, which were without any, quoting, any plausible scientific evidentiary basis, here, unlike that, the trial testimony of Montana's renowned climate scientists and medical professionals, none of which is challenged, proved causation as follows. First, as documented in findings of fact 140 through 193, greenhouse gas pollution from the combustion of fossil fuels has degraded Montana's environmental life support system, and as documented in findings of fact 194 through 208, the plaintiffs are suffering particular injuries to their health, their property, their tribal traditions, and their recreational interests. Second, as documented in findings of fact 212 through 237, the air pollution and climate change impacts that cause plaintiffs' injuries are directly tied to greenhouse gas emissions that result from defendants permitting fossil fuel activities, and as documented in findings of fact 259 through 267, those activities could not occur without permits issued by defendant agencies after conducting MEPA reviews. And third, contrary to the state's arguments that you've just heard that the emissions resulting from Montana's fossil fuel permitting activities are de minimis, as documented in findings of fact 214 through 237, defendants' fossil fuel-related permits are responsible for locally, nationally, and globally significant greenhouse gas emissions. And contrary to Mr. Sturmitz's argument just made, the testimony of both Nobel laureate Dr. Stephen Running and Regents Professor Dr. Kathy Whitlock, they testified, and this is as documented at findings of fact 89 through 92, that as a matter of scientific fact, each additional ton of greenhouse gases emitted into the atmosphere exacerbates impacts to the climate and increases harms presently experienced in Montana by the youth plaintiffs and will cause additional harms in the future, of course implicating the anticipatory and preventative provisions of Montana's Constitution. Turning next to Juliana, which defendants rely on in arguing that redressability is beyond the reach of Montana's courts, The Ninth Circuit's ruling was based on the determination that that court could not grant the relief requested, which was affirmatively requiring the federal government to develop a climate recovery plan. Here, the trial court granted declaratory and injunctive relief as to the constitutionality of specific statutes which Montana's jurisprudence clearly establish are appropriate forms of redress. As this court recently explained in Barrett v. State, quoting, "The redressability element of standing is satisfied because if the statutes are declared unconstitutional and enjoined by the court, the alleged harm will necessarily cease affording redress."
Counsel, could we be specific about what the alleged harm is? Because you've gone through all the findings, 140 through 193, that the district court made, which in my opinion were necessary to make before getting to the issue of the injury, which I think is that that information is not being considered by the permitting agencies. Is that the nature of the injury?
That is a component of the injury, Your Honor, and given the history of this case where all of the allegations were denied, you know, and motions through dismiss were made and argued, motions for summary judgment, et cetera. But as Justice Gustafson just noted in the recent Barrett decision, you can have standing predicated upon that kind of injury personal to the plaintiff or on the basis of constitutional infringement of right. In the instant case, we proved both.
Right, and I understand that argument. I'm asking, though, what is it, I guess with the limitation declared unconstitutional by the district court, where does that leave the plaintiffs in
Your
this?
Honor, with the impediments removed, the impediments of the challenged statutes removed, the district court concluded, and here's its determination in terms of alleviation, which is under Montana law, can alleviate and prevent further effects of Montana's fossil fuel activities through the lawful exercise of their authority if they are allowed to consider greenhouse gas emissions and climate change during MEPA review, which would provide, to your point, Your Honor, which would provide the information needed to conform their decision-making to the best science and their constitutional duties, and give them the necessary information to condition or deny permits when inconsistent with protecting plaintiffs' constitutional rights. And I think that it's important at this juncture to understand that unlike Bellin and Juliana, standing to assert the youth plaintiffs' claims is solidly based, as you indicated, Your Honor, on precedent of this court declaring unconstitutional statutes and regulations that violate fundamental rights, including MEIC 1, Park County, Armstrong, Weems 1.
And as the state points out, those cases were in the context of specific permitting decisions. And the district court went on in this case to say that to the extent the substantive permitting statutes would also not allow consideration of greenhouse gas emissions, those would all be unconstitutional too. And in your brief, I mean, the district court's summary judgment order said it could not compel, could not force the state to conduct that analysis. But you seem to think that, I mean, your brief says that agencies can and must evaluate greenhouse gas emissions under this order. So what is the scope of the district court's ruling following trial?
Your Honor, if I might unwind the question in kind of a step-by-step.
Good luck trying.
I think that it gets to this issue of discretion that counsel for the defendants were just arguing about. And in fact, contrary to their assertion, Montana's permitting statutes undeniably vest defendants' agencies with control over permitting for fossil fuel activities. And notably, the litany of statutes that they cite in their briefs clearly give DEQ discretion to condition or deny permits. For instance, the Clean Air Act of Montana at section 75.2.203 authorizes DEQ to establish emission limits from any source necessary to prevent, abate, or control air pollution. The district court correctly concluded that reviewing those statutes, the string cite that the defendants gave them, actually provides a roadmap for responsible agency discretion, which conclusion is only bolstered by the stated purpose of each of those enactments, which, like MEPA itself, explicitly provides that the legislature enacted them, quoting, mindful of its constitutional obligation under Article 2, Section 3, and Article 9. And so they have the discretion, and it is a matter of the agency doing the work it has to do. With those impediments removed, then yes, the agencies can move forward and bring their decision-making into constitutional compliance.
Counsel, what about from Mr. Schoengert's argument, though, just from a standpoint of justiciability, more as within the context of essentially a ripeness issue, though, that there is no permit that was being challenged here. So I get that what you're saying is that they should consider this, and the statute foreclosed them from considering greenhouse gas emissions when a permit is being considered, but isn't it premature just from a ripeness issue? And isn't this essentially asking for an advisory opinion as to whether or not this statute is constitutional if and when a permit is being sought?
Justice Shea, as proven at the 7-day trial when Montana's foremost scientists came from all across the state to testify, pro bono, spending hundreds of hours developing their expert testimony to establish that Montana is in the midst of a climate crisis right now. That climate crisis is being substantially contributed to by Montana's greenhouse gases that are permitted with those blinders in the MEPA process with the blinders on. The temperature goes up day by day. Maybe the temperature will be hotter tomorrow, but most surely, if nothing is done, it will be much hotter 50 years from now when those young plaintiffs are my age. Because of this climate emergency, to which the state of Montana is a substantial contributing factor, yes, this issue of the constitutionality of the state of Montana with those prohibitions in terms of agency review of greenhouse gases, they can't even consider it, nor can they come before this court seeking redress because of the double-headed hydra. And so, yes, this issue could not be more ripe.
Counsel, I don't disagree with you on the climate statements. It's hot out there today. I don't know if you've noticed, but it's a hot day. But the question Justice Shea was asking you to address was this idea of the lack of a concrete permit or process before us that you are challenging. And I want to read something from your brief, page 33. You say the permitting activities at issue here are clearly not beyond the reach of MEPA, focusing that the permitting activities at issue here, there are no permitting issues, no permitting activities at issue here. We have no permits before us. We have no process. It's interesting to contrast this case to the one we argued recently about the Laurel Power Plant. It's a MEPA case. The statute was applied there. The challenge statute that you are arguing was there, and it's argued as unconstitutional in a real case with a real permit. That is lacking here, and it seems like what you're trying to do is to obtain here some like a generic judgment that doesn't apply to anything in this case, so that that judgment can itinerate out to real live permit cases with concrete cases and controversies under the Constitution. Could you respond to that?
Yes, Your Honor. As the court is probably aware from reading the procedural history of this case, it started out challenging the constitutionality of the Montana Energy Policy Act, which prioritized fossil fuel extraction, and then also the MEPA limitation in the 2011 form. What we have succeeded here has already achieved redress to the extent that, as counsel conceded in the hearings below, the state repealed that obstructive Montana Energy Policy Act, and the district court here has taken the statutory blinders off of Montana's agencies, so going forward they can make decisions in constitutionally compliant decisions in all of the permitting activities before it. Therefore, Your Honor, the preventative, the anticipatory and preventative aspect and dimension of this case could not be more clear. And I think that it's important to, keep in mind here that this is, after all, based on the Montana Constitution. And the Montana Constitution, as pointed out, in distinction to the other cases, both the federal cases that they're citing and the out-of-jurisdiction cases that they're citing, it's important to keep in mind, as was done in Jacobson 2024, the source of the right in the unique provisions of Montana's Constitution matter. The delegates intended the Declaration of Rights to stand on its own footing and provide individuals with fundamental rights and protections far broader than those available through the federal system in order to meet the changing circumstances of contemporary life. And protecting Montana's environment was first among those circumstances of contemporary life that the delegates were concerned with, to make sure that we had an anticipatory and preventative dimension to that constitutional right to prevent degradation of the environmental life support systems. And these statutes that are before you are in absolute opposition to those constitutional provisions. And as proven at trial, Your Honor, going to what was proven at trial, Montana's environmental life support system has been degraded, and it's threatened with far further degradation through the climate change impacts that cause the plaintiff's injuries that are directly tied to the greenhouse gas emissions that result from defendants permitting fossil fuel activities after blindered MEPA review. And so I think that the causal link from the injury facts to the causation to the redressability that was achieved, some of it was achieved earlier in the litigation with the revocation of the Energy Policy Act, and then finally taking off, as declaring unconstitutional, both heads of that double-headed hydra of which I spoke. That is redress. We have the hope here of Montana's agencies exercising the discretion that they have in a constitutionally compliant manner. If they do, then they will be able to evaluate these permits within the context of that framework. I do think that it's important to look at Bitterrooters. They've relied a lot in their briefing, and both counsel have indicated their reliance on it again this morning. And they rely on it to argue that MEPA has no causal impact on fossil fuel permitting statutes, and therefore does not require analysis of the effects of greenhouse gases, by the way, even without the MEPA limitation. That's their argument. While Bitterrooters is clearly factually distinguishable, the legal principles are entirely supportive of the district court's legal conclusions in this case, because here, as proven at trial, the air pollution and climate change impacts that are the cause of plaintiff's injuries are directly tied to the greenhouse gas emissions that result from defendants permitting fossil fuel activities after conducting their blindered MEPA review. And those activities could not occur without agency-issued permits, and that's findings of fact 29 through 260 through 268 document that causal link. And to the and I think that it's also important, Your Honor, to understand that the Constitution, as this court's aware, controls MEPA and not vice versa. And it's important to keep in mind how MEPA uniquely fulfills the constitutional purpose within the ecosystem of Montana's environmental laws. As this court noted in Bitterrooters, MEPA requires an agency to take a hard look of the environmental impacts of a given proposal, and attendant to that hard look is the obligation to make an adequate compilation of relevant information, to analyze it reasonably, and to consider all pertinent data. Integral to that hard look is MEPA's requirement that the agency complete a significance of impacts analysis. Thus, DEQ's own MEPA regulations require that the agency shall consider the severity, duration, and geographic extent of each impact. And as the court explained in the Ravalli County Fish and Game case that Bitterrooters cited with approval, without the mandatory significance of impacts analysis, the agency is unable to take the required hard look and unable to determine whether it has complied with MEPA's stated intent to, quote, fulfill the responsibilities of each generation as trustee of the environment for succeeding generations. Clearly, the MEPA limitation undermines MEPA's constitutional purpose and its, quoting from Park County paragraph 76, its unique ability to avert potential harms through informed decision-making. Based on the undisputed evidence, the district court properly determined that these statutes implicate the plaintiff's fundamental right to a clean and healthful environment, which triggered strict scrutiny.
And counsel, that would be why you would not need to have a permitting case in front of you. In other words, you could consider the limitation without being in the context of a permitting case because it involves a fundamental constitutional right.
And it's preventative, it's anticipatory and preventative dimension. And what we have shown is that as a result of the state's statutory framework, it has harmed these children. That gives us constitutional standing to come before the district court and this court. And the expert testimony documented that what had happened in one permit approval after another was that they weren't properly evaluated. The large fossil fuel greenhouse gas emission permits were approved one after the other. This is the appropriate mechanism to challenge what is going on impacting these youth plaintiffs and indeed all young Montanans now and into the future. It is that dimension of constitutionality that clearly gives them standing to come before this court, Your Honor. And back to the point of strict scrutiny, the district court, based on the undisputed evidence, properly determined that these statutes implicate the plaintiff's fundamental right to a clean and healthful environment, which triggered strict scrutiny. At no time have defendants presented any evidence of a compelling government interest to justify the MEPA limitation or the judicial prohibition. Based on the trial record, the Montana Constitution, and this court's precedent, there is grave constitutional infringement occurring on the ground right now, harming these youth plaintiffs. If our Constitution is to mean anything, then MEPA must be used by the agency as intended to conduct evidence-informed analysis to evaluate whether fossil fuel permitting decisions can overcome a strict scrutiny analysis in light of the fundamental rights that are already being violated. In conclusion, adopting the state's arguments would eviscerate the protections of Montana's fundamental rights. The district court properly concluded there are constitutional level injuries occurring now with current levels of greenhouse gas emissions. The uncontroverted evidence established that Montana's fossil fuel pollution is contributing and worsening the plaintiff's injuries, and the challenged MEPA statutes are culprits. But the protections provided by the Montana Constitution are only as strong and enduring as the judiciary's resolve to enforce the framers' clear intent. And we were honored to have at trial as our first witness, Delegate Maynann Ellingson, who explained how important this anticipatory and preventative right was to the delegates. It was the first delegate proposal that was considered. And I would also point out that Ms. Ellingson has honored us with her attendance today. And as indicated, the protections that have been provided in our Montana Constitution by the forethought of our framers are only as strong and enduring as the judiciary's resolve to enforce its clear text. We respectfully submit on this trial record documenting the environmental crisis impacting now on the ground all across Montana these children's health and well-being, that the district court's well-reasoned decision striking down two clearly unconstitutional statutes should be affirmed. This is the result that present and future generations of Montana children deserve and the Montana Constitution requires. Thank you.
Mr. Schonger.
Just a few points in rebuttal. First, I think my friend has made clear that the problems with considering this case in the abstract. We're arguing about what substantive permitting statutes require and don't require, whether they require greenhouse gas analysis or not, outside the context of any permit, outside the context of analyzing whether that is indeed the case. And that's the problem. Part of the problem with this case is that the court is being asked to address those issues of what is required as far as greenhouse gas emissions analysis in the abstract. Second, I'd like to talk about...
That's not exactly right, is it? I mean, court's not being asked to determine what should be in a greenhouse gas emission. The only question before the court is whether or not the state agency is precluded from looking at greenhouse gas emissions.
I don't think so, Your Honor, and this goes to the plaintiff's claims throughout this case and the district court's decision, concluding that Montana law would require substantive permits to be denied based on greenhouse gas emissions analysis. That was the basis for the court's redressability holding at page 90 of the opinion. That's what's missing.
Isn't it based more on the information will give the agency the ability to make well-informed decisions on that which is anticipated to result in what you're claiming the plaintiff is saying now, right? Which is slightly different.
Slightly different, but that wouldn't redress the plaintiff's claims. Their claims are not informational. As my friend said, it's a component of the injury, but not their relief, and the district court made this clear. The district court didn't depend on that information either at page 90. It was the actual denial of permits and reduction of greenhouse gas emissions that would alleviate plaintiff's injuries. And this court has adopted that standard in Larson, and it applies whether it's a fundamental right or not. The court in, for example, Park County, fundamental right case, applied that very analysis requiring, and it was the same fundamental right at issue in this case.
Counsel, does the injury have to be redressed in total?
No.
Or okay.
It can be alleviated, but no evidence in this case suggests that it would be alleviated at all because MEPA doesn't require the agency to deny a permit. For even assuming denial of 20 permits, let's say, would alleviate the injury, there's no evidence in this case that a single permit would be denied. And case in point, the permits that were analyzed for greenhouse gas emissions before 2011 or after 2011 with the federal partner, not a single one of them was denied. And I'd like to mention, Justice Baker, you asked about the 3 before 2011. 2 of the 3 were done in conjunction with federal partners, which would not be permitted or prohibited under the statute.
Would the agency have authority to consider rulemaking for greenhouse gas emissions if the MEPA limitation wasn't there? Or do they have authority to do that with the MEPA limitation there? Does it matter?
I don't know that they do with the MEPA limitation. I'm not sure. I think they generally have, pretty broad rulemaking authority to consider various things. I don't, and that's part of, I think, the plaintiffs can seek redress through rulemaking. They can seek redress through legislative change. The extent, I'm not, frankly, an expert on the rulemaking process, so I don't know what the extent of their authority would be, the agency's authority would be with regard to that.
But that gets back, counsel, to the point being that right now, nothing can be done. Nothing.
Right,
because
but
of
it's
the
unclear whether
limitation.
anything would be done anyway, because it's unclear whether the greenhouse gas emissions must be analyzed within the context of any substantive permitting statute. They skipped the first step. I think they've got to show that there is authority to deny permits on that basis, and the court can evaluate all those questions in the context of an actual permit, not in the abstract like we have here.
Well,
So-
why wouldn't there be an authority to deny a permit on that basis if it was established that the emission of greenhouse gases presented a danger to the environment and health? Why would that not be a basis to deny? Because of other substantive provisions?
I think it depends on the context. It depends on the permit itself and what the claims are. It certainly could. There's no doubt that it could. It's whether it
But
would.
how would they know if they're precluded from considering it?
I
Guess I'm having trouble in this circle we're going around.
Well, I mean, I think the same way they did in MEIC 1. They argued that non-degradation, the agency didn't conduct adequate non-deg review, and ended up being right. And so I think Park County, they challenged that they didn't do adequate review, and so I think it'd be that same path for any other permit challenging this statute. Eating into my friend's time if there are no more questions. Thank you very much.
Mark Sturmitz again for the state of Montana. Regarding the question of how would they know, I'd like to direct the court's attention to what we do know, and this comes from the plaintiff's evidence at trial. The CO2 loading globally in the last year that they calculated it was about 40 billion tons. China contributes about 9 to 10 billion tons of that 40 billion. Plaintiffs assigned Montana 166 million tons, half of which was transportation. It was fossil fuels that we don't extract, we don't combust. They just travel through our state. We have very limited control. For example, take the Yellowstone pipeline that 24/7 is transporting gasoline through the state of Montana. That went into our mix. There was no recognition for federal or tribal control over much of like coal leases and also anything. So if you removed the amount just for transportation, that would take about half of Montana's 166 million ton total, and you're down to, which I would say it would be appropriate, first of all, because of the lack of control over that and the fact that it's not being combusted in Montana. That would take us down to about 83 million tons per year, which just simple math compared to the global load would be 0.0019%. So this substantial factor. The rhetoric that is conveyed as if Montana is the sole source of this problem that everyone recognizes exists, it has to be reviewed in the context of those absolute scientific facts that came from plaintiffs' witnesses.
Mr. Sturmas, is that 40 billion? It's 40 billion, correct?
The total 40 billion.
Global load. I didn't see that referenced in the district court's findings of fact. Where does that come from?
It's in the,
Evidentiary record,
I
excuse me.
think we cited it in, and I can get cites, but it may not, that may not have found its way into the district court's findings.
Yeah, it did.
Did it?
Yeah.
I mean, there's much that was omitted. That's part of the problem we have with the district court's findings. The plaintiff's witnesses were hesitant to talk about this stuff. They didn't want to do those math. They didn't want to do the comparison for one legitimate reason, which is that
What does that refer to? 40 billion
tons of CO2 equivalent per year,
that's introduced globally
globally,
pursuant to fossil fuel burning?
correct. I did want to point out, too, in the short few seconds I have, that I was mistaken. We did cite the Schoof case in our brief, our reply brief, on page 7. And the point there is that that was a constitutional right to know case, that standing depended on redressability. The court said whether the constitutional or statutory provision can be understood as granting persons in plaintiff's position a right to judicial relief on a fundamental constitutional right. So it's not standing, the normal standing analysis isn't abrogated by the fact that there's a constitutional provision in question. Thank you very much.
This concludes the argument in this interesting case. Thank you to all counsel. We will take this matter under advisement and issue an opinion in due course.